Registrar. Registrar. Registrar, can you hear me? Registrar, can you hear me?
Yes, my lord, I'm here.
Yes. Are you ready? Are you ready? Registrar. Can you hear me? Registrar.
Yes, my lord, I'm ready.
Okay, can you hear me?
My lord, I can hear you.
Are the council present? Are the council present?
Yes, my lord. The defendant's counsel is ably represented, my lord.
Okay. Then we can start. Registrar, you can call the case.
I'm here, my lord. Yeah, I can hear you, sir.
Call the case. Yes, call the case.
Okay, suit number NICN/LA/102/2017 between Mr. Efemona Opuvo and APM Terminals Apapa Limited.
Yes.
Parties are absent.
Representation of counsel. Appearances.
With utmost humility, my lord, Matthias Dawodu.
What?
Matthias Dawodu, my lord.
Matthias
Dawodu, my lord.
Okay.
I will announce appearance for the defendant.
Okay. Any appearance for the claimant? No appearance for the claimant. Registrar. Registrar.
Yes, my lord.
Was the claimant served with the hearing notice?
Yes, he's aware of today's sitting.
Okay. Okay. The judgment is ready. I will read the introduction, the reliefs, and the case as presented by both parties, and I will skip the counsel submission and read the decision portion. It goes this way. Can you hear me?
Yes, my lord, we can hear you.
Okay. By general form of complaint dated and filed on the 3rd of March 2017, which was accompanied by the statement of facts and other front-loaded documents, which the claimant later amended, the claimant brought this case and seeks for the following reliefs. 1. The sum of 256,219 naira 32 kobo being 1 month's salary for the month of August 2015, the month the claimant's job was terminated. 2. The sum of 256,291 naira 32 kobo being 1 month's salary in lieu of notice of termination of employment. 3. The sum of 4,985,417 naira 2 kobo being his total terminal benefits as duly computed as per the company policy in line with the collective trade agreement applicable to staff, including the claimant. Number 4, the sum of 5 million naira only being damages for wrongful termination of employment. 5, the sum of 10 million being damages for unlawful detention for 5 days at the prompting of the defendant at Port Authority Police Command in August 2015. 6, interest at the rate of 25% on the total sum from August 2015 till date of judgment, and thereafter at 10% until the judgment sum is fully liquidated. And the cost of this suit as may be assessed by these courts. The defendant in reaction filed its statement of defense together with the documents to be relied upon at the trial and witness statement on oath of its sole witness in the person of Olayinka Oluwakemi Akiladi. The defendant later amended the statement of defense. Trial in this matter commenced on the 28th of November 2018 and was concluded on 9th of November 2019, following which the court ordered the filing of final. It is the case of the claimant that by a letter of employment dated 11th of November 2018, he was employed by the defendant as truck driver with effect from 14th of November 2008. Let me come again. The claimant's case is that by a letter of employment dated 11th of November 2008, he was employed by the defendant as a truck driver with effect from 14th of November 2008, which later was admitted in evidence and marked as Exhibit C1. That the claimant's appointment was subsequently confirmed by a letter dated January 29, 2009, with effect from 15th of February 2009, which later was admitted and marked as Exhibit C2. Claimant also contended that based on his exemplary performance, he was promoted to the position of rubber tire guarantee crane operator with an enhanced salary of 262,382 naira 23 kobo per month, or 3,148,586 naira 77 kobo per annum. The claimant alleges that he worked diligently and satisfactorily for the period of 7 years with the defendant. It is the case of the claimant that his superior officers were envious of his accomplishments and conspired to terminate his appointment. The claimant stated that upon acting on the instructions of his superiors, he was arrested alongside his superiors for the commission of an alleged offense. The claimant alleged that he was unlawfully detained at the instance of the defendant for a period of 5 days and that his superiors were indicted and charged for the crime while he was released and discharged by the police. See paragraph 6, 7, and 8 of the statement of facts. It is the case of the claimant that the defendant determined his employment by a letter of dismissal dated 18th of August 2015. The letter of dismissal was tendered by the claimant and admitted in evidence and marked as Exhibit C4. The claimant stated that he wrote letters to the defendant protesting his dismissal, but the said letters were ignored. A letter dated 27th August 2015, 26th of February 2016, and 1st of April 2016 were tendered and admitted as Exhibit C5. It is the claimant's case that his dismissal by the defendant was based on alleged crime for which he was exonerated by police report dated 25th of January 2017. The police report was tendered and admitted as Exhibit C6. It is the case of the claimant that he is entitled to terminal benefit based on memorandum of agreement between the defendant and Maritime Workers Union of Nigeria. The memorandum of agreement between the defendant and the said Maritime Workers Union of Nigeria was tendered and admitted as Exhibit C8. The claimant stated that the collective trade agreement was the basis for the computation of the terminal benefits for Mr. Eberechukwu Emeronye. The claimant tendered the computation of redundancy payment and receipt of Mr. Eberechukwu Emeronye. The same was admitted as Exhibit C9. The claimant later stated that he instructed his auditors, a firm of chartered accountants, Misery Henry Ibadi and Co., to compute his terminal benefits based on the collective trade agreement, and the auditor's report of the computation was issued to the defendant. The claimant tendered the letter of instruction and auditor's report dated the 28th of October 2017 and 30th of October 2017, respectively. The documents were admitted as Exhibit C10 and C11, respectively. The case of the defendant. The defendant's case is that the claimant's employment was made subject to the claimant's letter of employment, employee handbook, and code of conduct. The defendant contends that the claimant has not presented the complete and true facts of the case before this court. The defendant tendered the complete letter of employment dated 11th of November 2008, the employee handbook issued to the claimant on 5th of February 2009, together with the acknowledgement slip duly executed by the claimant, and the code of conduct signed by the claimant on the 16th of September 2010. The documents were admitted as exhibits and marked respectively as exhibits D1, D2, and D3, respectively. The defendant contended that the claimant was never exemplary performance, and the allegation of diligence and unblemished performance by the assertion of diligence and unblemished performance by the claimant is unfounded. The defendant stated that in the course of the claimant's employment, the claimant was issued with several queries, written warnings regarding the infraction of the terms of his employment, the employment handbook, and the defendant's code of conduct. The defendant stated that the claimant was involved in the vandalization of a container carrying a shipment belonging to Pearson Healthcare PLC. The defendant stated also that the events leading to the vandalization of the said container caused reputational damage and economic loss to the defendant. The damage and loss caused to the defendant was portrayed in the letters from Libya Cycle Limited dated August 14, 2015 and 19th of August 2015, which letters were admitted and marked as exhibits D7 and D8, respectively. The claimants also stated that the superiors of the claimant were not parties in this suit, and as such, the allegation of envy and conspiracy leveled against the superiors of the claimant by the claimant ought not to be a question for determination by this court. The defendant further stated that it acted within its legal obligation and clause 853 of the employee handbook to promptly report incidents of crime to the police when it reported the incidents of vandalization and theft to the police. The defendant stated that the purported police report exonerating the claimant was issued 17 months after the dismissal of the claimant. The defendant also stated that the alleged maker of the report was not listed as witness in this suit, and that the police do not have duty to issue exoneration letters to investigated persons. See, it is the case of the defendant that the defendant had the obligation by virtue of clause 8.7 of the Employee Handbook to conduct internal investigation independent of the police investigation. The defendant stated that the employee involved in the incidents, employees involved in the incidents were appropriately heard, and it was in the course of the hearing that the claimant admitted that he had violated the defendant's standard operating procedure by failing to update the system about the location of the container. The record of the inquiry/hearing on 18th of August 2015 was tendered and admitted in evidence and marked as Exhibit D9. The claimant also admitted not to adhering to the standard procedure by the claimant. The claimant also admitted not adhering to the standard of procedure in the claimant solicitor's letter dated 26th of February 2016, which was admitted and marked as Exhibit C5. It is the case of the defendant that the claimant did not exhibit the level of diligence required of him in accordance with the standard operating procedure, SOP, duly put in place by the defendant for all its staff, and as a result, caused economic and reputational loss to the defendant. The defendant's standard operating procedure for BMT RTG operation was tendered and admitted as Exhibit D10. It is the case of the defendant that the dismissal of the claimant was in strict compliance with the terms and conditions of his contract of employment, the employment handbook, and the code of conduct. It is also the case of the defendant that the claimant is not entitled to terminal benefit based on the memorandum of understanding, memorandum of agreement reached between the management of the defendant and the Maritime Workers Union of Nigeria. The defendant stated that the memorandum of agreement provided only for redundancy, gratuity where employee was not dismissed, and medical welfare of an employee. The defendant states that the memorandum of agreement was effective from January 2010 to December 2011 and was no longer applicable as at the time of the dismissal of the claimant. I now proceed to read the decision. After careful consideration of the processes filed, the evidence laid, and the arguments of counsel with the authorities cited in the final written addresses, the claimant's case is founded on wrongful dismissal. The claimant's claims for 6 reliefs, 3 of which are for special damages. The issue calling for the determination of this court is whether the claimant has established a case of wrongful dismissal against the defendant and is thus entitled to any or all the relief sought. The onus is on the claimant to prove his entitlement to the relief sought. It is the law that an employee or servant, as in the instant case, who complains that his employment has been wrongfully terminated or abruptly brought to an end, must found his claim on the contract of service and show on what manner the wrong was done. He must plead and prove the contract of service, which is the bedrock of his case. It is not in principle for the employer, who is the defendant, to prove that the termination was not wrongful. See the case of Ahmed against ABU and others, citation supplied. That this therefore imposes on the claimant herein the onus to prove A, the employment relationship, B, place before the court the terms of employment, C, prove in what manner the said terms were breached by the employer. Now, it is a common ground that the service contract between the parties herein was governed by the claimant letter of employment, Exhibit C1, and the defendant's employee handbook, Exhibit D2. When a contract is contained in a series of documents or letters or correspondences, the court is under a duty to consider the whole of what has passed between and the conduct of the parties. In the case of Anima Shaun and another, versus Ogudimu and others, and SAPE versus Nigerian State Marketing Board. Citations supplied. Now, the claimants did not give the factual details leading to his dismissal in the statement of facts. The claimant only averred at paragraph 8 of the statement of facts that he was arrested, interrogated by the police, and later exonerated of the allegation of conspiracy to commit crime against the defendant. At paragraph 9, the claimant averred that upon his exoneration, on the ground that he committed no infraction but merely acted on the instruction of his superiors whom were indicted and charged to court by the police, that he went back to his duty post but was summarily dismissed on the 18th of August 2015 by the letter of dismissal, Exhibit D4, C4, I mean, for the same reason of the alleged crime. The claimant did not aver to facts as to the offense he was accused of committing. He also did not give factual account of the incidents. It is instructive to note that the law is sacrosanct, that pleadings must be specifically set out comprehensively and accurately stated. Prevarication is an anathema to good pleadings. It depicts double talk. See the case of Bosharun and others against Ogulewe, citation supplied. Facts must be concisely, precisely, and accurately pleaded. Pleading should not give room for doubt or speculation as to its real content. See the case of Ochuji against Ekioka, citation supplied. Now, the defendant at paragraph 25 of the amended statement of defense averred that it conducted its own internal investigation, independent of the criminal investigation. Was breach of its standard operating procedure. That during the said hearing, the claimant admitted that in violation of the defendant's standard operating procedure, he failed to update the system about the location of the container, and that he did so at the behest of one of his accomplice, Obeta Oyemeseli, the claimant supervisor. The defendant also tendered Exhibit D9, the report of the corrective learning inquiry meeting, in which the claimant admitted that he did not update on the system the said container box as outlined in the company's as authorized by the standard operating procedure, and that he omitted to do so to update on the instruction of Mr. Obeta, his supervisor. Now, the claimant did not file a reply to the defendant's statement of defense to react to this allegation of fact made by the defendant. The legal effect of such failure is that the claimant is deemed to have admitted those facts pleaded by the defendant. I refer you to the cases of AG of Abia State against AG of Federation, Abdullahi and another against Rabi and others, Mogalu and another versus Mogalu and another. Citation supplied. Now, the fact as to the existence of the employment relationship between the parties herein is not in dispute. Also not in dispute is the fact that the parties herein have tendered the terms governing the employment relationship. The issue in dispute is whether, in view of the facts and circumstances surrounding this case, the claimant has proved wrongful dismissal and is thus entitled to the relief being claimed. The claimant's argument is that he was not accorded opportunity and that proper procedure for disciplinary action was not followed, that he was reported to the police but was discharged and cleared of any wrong via Exhibit C6, that the defendant then hurriedly concocted a kangaroo panel to investigate and conduct trial on the claimant on the 18th of August 2015, that is Exhibit D8, that the claimant was dismissed upon the unsubstantiated allegation even when the claimant showed clearly at the trial that he acted on the instruction of his supervisor. The defendant's reaction in this regard is that not only was the claimant given the opportunity to explain himself, he also confirmed that he has participated in the laws under the instruction of his supervisor, thereby violating the employment contract and the standard operating procedure of the defendant. Now, under the defendant's employee handbook, clause 9 in particular, which deals with staff discipline, one of the dismissible offenses is theft, dishonesty in connection with the company business. Paragraph 4.12 deals with summary dismissal of, and it provides inter alia, and I quote, notwithstanding any other provision of this employee handbook, repeated offenses or any offense that in the opinion and the view of management constitute gross misconduct shall attract the summary of dismissal of the employee. End of quote. Now, as I said before now, the claimant did not deny his role in the vandalization of the container. His defense is that he acted under the instruction of his supervisor. The question to ask is the claimant justified in acting to the detriment of his employer on the instruction of his supervisor? I think not. It is the law that gross misconduct is a conduct that is of grave and weighty character as to undermine the confidence which should exist between an employer and an employee. See the case of Umo against ITGC, citation supply, or watching against the deep interest of the employer. He could be lawfully dismissed, therefore, summarily, without notice and without wages. The claimant alleged that he was exonerated by the police after conducting investigation into the allegation of crime against him and two other staff of the defendant. I do not think the claimant's exoneration by the police can shield him from facing disciplinary action by the defendant. It is the law that where there has been admission of misconduct or crime by an employee, and as in the instant case, the need for proof before a regular criminal code no longer arises. Prosecution of an employee before the law code is not a sine qua non for the exercise of the power of summary dismissal for gross misconduct if there is allegation of crime. It is the law that an employee owes a duty to his employer to protect his property or use same in such a way that no preventable loss would occur. Where he is tardy or there is lack of diligence in his approach to his duty, or he is negligent and the master by the same suffers loss due to the unacceptable and untoward behavior of the employee, such employee is guilty of misconduct, to which appropriate disciplinary action can be taken against him. I refer to the case of Abomeli against NRC and other cases here. In the instant case, failure of, or refusal of the claimant to update the system about the location of the container and on the instruction of his supervisor is a violation of his duty to the dependent, which in my view constitute a gross misconduct. I find and I so hold. I am also in complete agreement with the argument of the learned counsel to the dependent that paragraph 1 of Exhibit D3 imposed an obligation on the claimant to notify the dependent's management if he becomes aware of any act of dishonesty or other breaches of the dependent's code by others, but the claimant failed and or refused to notify the management of the dishonest and fraudulent instruction issued to him by his superiors. This I find is also a gross misconduct that can undermine the defendant's business, and I so hold. The claimant also sought to rely on Exhibit C11 to claim for terminal benefits. I do not think the claimant can claim for terminal benefit in the circumstance of this case. The claimant's dismissal from the defendant's employment has, in my view, deprived him of any terminal benefit. I am therefore at one with the submissions of the learned counsel to the defendant that the claimant's case is founded on dismissal, not redundancy, as can be seen from Exhibit C4. The claimant also sought to rely on Exhibit C8 in support of his claim for terminal benefit. I have carefully examined Exhibit C8, which is the memorandum of agreement executed between the defendant management, the Maritime Workers Union of Nigeria. As rightly argued by the defendant, the said agreement does not cover cases of dismissal. It operated from January 2010 to December 2011, and same was confirmed by the defendant, by the claimant under cross-examination. Now, it followed therefore from the foregoing that the claimants cannot place reliance on Exhibit C8 to claim for terminal benefit, having been dismissed from the defendant's employment. Even if the claimant was not dismissed, I do not think he can rely on Exhibit C8 because the said exhibit was no longer in operation at the time the claimant left the defendant's employment. I find and I so hold. In the final analysis, and for all the reasons stated, I find that the claimant's case lacks merit, it fails, and is accordingly hereby dismissed. Judgment is entered accordingly. I make no order for cost.
As the court pleases.
As the court pleases.
We are very. My Lord, we are very grateful for the well-considered judgment, my Lord.
You are welcome.
My Lord, we are indeed grateful for the considered well.
That will be the end of today, sir.
Who is speaking? Who is speaking? Registrar.
Yes, my Lord. Yes, my Lord.
I heard somebody speaking. Huh?
I heard the same thing too. Maybe one of the counsel.
I believe, my Lord, that should be the claimant's counsel, my Lord.
But he did not announce appearance.
Yes, my Lord. I have a problem with. Yes, my Lord. I had a problem with my audio. My name is Dixon Honor, my Lord. And
I cannot see you.
I have problem with the
video.
Very sorry about that.
Turn on your video. I cannot see you. I cannot record you without seeing you.
Yes, my Lord. I was on.
So that I can see you.
Turn
on your video so that I can see you.
Stop, please.
Yes.
Yeah, I tried to, my Lord, but I have an issue. I think I'm on now, my Lord.
I cannot record your presence without seeing you cancel. I cannot. I'm sorry. I cannot do that. Turn on your video. Okay. Okay. Now that I can see you.
Yes, my Lord. My video is on now, my Lord.
Okay.
Yes, my Lord.
You said Dixon Honor.
Dixon Honor, my Lord, for the claimant.
Oh, did you write down?
Dixon Honor, my Lord.
Okay.
My Lord,
Dixon.
we've been privileged to listen to the. Yes, my Lord.
Go that alone.
Yes.
How is the case now?
Yes, my Lord, we've been privileged to listen to the well-considered judgment of the court. We will review the case as appropriate and do the needful, my Lord. We are most indeed grateful for the time and the scholarship put in the judgment. We are grateful, my Lord.
You're welcome. Thank you. Yes, right. That's all.
Yes, my Lord. That will be all for today. That will be all for today.
The court shall rise.
Court.